for notice to all the parties. I mentioned this whenever with regard to the MPS matter, the paying matter. You know, the state government is appears in spite of best of efforts, being made even pursuing the Attorney General's office but we have been denied the appointments of the staff which is very much required. And as a result, the entire
Staff are not there.
more than 10 staffs are still appointed. Those who have already the term has been over. We are asking for extension. Even that has not been done. No, my lord, your office. They say we will
Ask the advocate general to be present at meeting.
My lord, appeal against acquittal.
Lord, for contempt, inclusion of the contempt application, my lord. For last 10 years, the advocate was debarred, my lord, from practicing. My lord, the order was passed in the year 2015. It would be on listed for after 3 months, but it was not released.
Department is not providing me a copy.
Yeah, give you
So, court order they are not.
when I get
Lordship bail in connection. It's bail in connection with appeal, lords.
To make it inquiry I've seen the FIR and charge sheet filed by the police. Then I guess matching with the
let the inquiry, and we have directed an inquiry on this issue and also the authenticity of the document. Let the report come under section 95.
and so on this document.
Yes, the document will not do.
These are part of
It
it.
has to be proved. The school register has to be produced, the headmaster has to be examined. The inquiry is in a full-fledged recording of evidence. Yes, call the
Item number 1.
My lord, item number 1, I am appearing on behalf of the respondent NCB.
minor and may be ignored paper books within 4 weeks.
Wait, my lord.
Yes, sir.
Paper books prepared, 4 weeks. Next.
Lord, item number 10, my lord, I am for the petitioner, my lord. Tran 1 is for correction of the name on 7/2 that has been dismissed, my lord. Tran 1 is for correction of the name. हाँ हाँ এই নামটা কারেকশন হবে নামটা সেকেন্ড পিটিশনারের নামটা কারেকশন আজকে আবার লিস্টে চলে এসেছে ডিসমিস হয়েছে কেন ওইটা কি বলতে হতে পারছি না
Please, my lord. But kindly seize the last order passed by your lordships, my lord. Particularly, my lord, paragraph 7 there.
দুটো কেন ও দুটো কেন
খুলে গেল কি করে? My lord, no notice was issued pursuant to that, my lord. And ওদের কপি দেওয়া হয়েছে?
Well, first matter, my lord, there is no order. Although your lordship passed the order that notice should be served, but first matter there is no order to serve notice. So, my lord,
My lord, both are
both are
linked, my lord. No notice,
no.
same petitioner.
Last portion is there is a separate case number and order, and on the top, my lord, two case number. How? Yes, it has been served. But my lord, within 2 years, 6 notice was served. Second notice he told my lord 2023 that I am under treatment. Now 2024, my lord, similar statement. Yes. I go application for bail.
I owe the order.
Order. Yes.
It.
Yes. Yes. Submitted that nothing has been placed record so that later dated was received by the department. He seeks leave to take instruction in this matter. Yes. It was received. Yes. But my lord, this is second. My submission should be recorded. This is my lord. Second application is not maintainable. There is no change circumstances. Second, my lord, 6 notice. My lord, 6 notice within
In circumstance.
as your lord said.
Don't make drama with liberty of people, right? If you need his custody, tell us. This is not drama, sir. If your family member was implicated like this, you wouldn't have felt happy if the lawyer for the department said, this is not there and that is not there. Do you seriously require custody? Tell us. No, let him go for trial.
As your lords.
As your lordship. Petitioner has renewed his prayer
Put a
for
copy go there.
pre-arrest bail. He contends he was no narcotics was recovered from his possession. He has been implicated in a series of he has been falsely implicated in a series of cases. Earlier prayer for pre-arrest bail was rejected on the ground that he did not respond to notices under 67 of NDPS Act. Letter dated 23/3/2024 served up senior counsel contents contents during hearing of the said application. Letter dated 23/3/2024 sent to the department in response to the summons. In response to the summons issued upon his client had not been placed before this court. In light of the aforesaid document, Now, relying on this document, he contends that his client had responded to the notice and was available for interrogation. He praised for reconsideration of the earlier order in light of such changed, in light of the additional materials before this court. Learned counsel for, in view of this submission, we called upon learned counsel for NCB to verify whether the letter dated 23/3/2024 categorically denying involvement of the petitioner in narcotics activity was served on the department.
Report also.
Learned counsel admits, places on record document which shows the said letter had been duly received. Duly received. He, however, contends that petitioner had not physically attended interrogation. He, however, contends those 6 notices were issued, petitioner had not physically attended interrogation. We have considered the materials on record. No narcotics was recovered from petitioner. His complicity has transpired from statement of co-accused before police officer, before the inquiring officer under 67 NDPS Act, which are inadmissible in law as per Tufan Singh. His prayer for pre-arrest bail, his earlier prayer for pre-arrest bail was turned down on the premise that he had not responded to the notices served under section 67 NDPS Act. Presently, petitioner has placed on record a letter dated 23/3/2024, which shows that which shows he responded to the earlier notices, which shows wherein places on record letter dated so and so, wherein petitioner, in response to the notice under section 67 NDPS Act, categorically denied his involvement in the narcotics trade and disclosed the bona fide business through which he earns his livelihood. Full stop. Nothing is placed on record to show the inquiring officer looked into the inquiring officer had verified the statement of the petitioner in the said letter. On the other hand, he mechanically issued another notice dated 21/5/2024, which, however, was not responded. Full stop. Upon verification, upon query from the bench, learned counsel for NCB is unable to enlighten us with regard to unable to enlighten us whether further investigation is in progress or such process would entail custodial interrogation, petitioner's custodial interrogation. Under such investigation in the case is given this situation, we are constrained to hold. We hold that investigation in the case is complete, and no credible and or legally admissible evidence connecting the petitioner is placed on record. Though earlier plea for pre-arrest bail had been turned down on this sole ground that petitioner had not responded to the notices under Section 67 NDPS Act. Subsequently, he has placed on record letter dated 23/3/2024, wherein he has explained his legitimate business activity, legitimate business activity as his source of livelihood, and denied his involvement in the alleged narcotics trade. Not NCB is no investigation was undertaken by NCB with regard to the data made available to them by the petitioner in the said letter. It appears upon query, we are satisfied. Further investigation, we are satisfied. NCB does not propose to undertake any further investigation in the matter also. In such view of the matter, also, in this backdrop, we are of the opinion subsequent material, namely letter dated 23/3/2024, showing response of the petitioner to notice under Section 67 NDPS Act, supplying information to the petitioner with regard to his legitimate sources of income and bona fide business activity, discloses his bona fide to join in investigation, and changes the profile of the accuser, changes the profile of the case vis-a-vis his availability and cooperation to the investigation itself, In this backdrop, accordingly, we are inclined to reconsider our prayer for pre-arrest bail and entertain the present application in this change, entertain and allow the present application in light of the changed circumstance, in light of the altered circumstances. Full stop. Application for anticipatory bail is allowed.
Most of it.
Next. From the petitioner, his complicity has arrived from statement of co-accused before inquiring officer under Section 67. Full stop. Learned counsel for NCB strenuously contends petitioner did not join the investigation. In light of this submission, opportunity was given to NCB to issue notice under Section 67 NDPS Act to interrogate the petitioner. NCB has not availed of such opportunity, making it clear that it does not propose to open further investigation or subject the petitioner to custodial interrogation. In light of the aforesaid facts, we are of the opinion petitioner has been able to rebut statutory restrictions under the NDPS Act and may be granted answer.
My lord, a report file, my lord, kept on record.
Yes.
And in this matter also
Reports are placed.
Both matter.
Obliged.
Deeply obliged, ma'am.
Thank you.
Yes, I am for the petitioner.
We have intimated the victim girl, my lord. She is
My lord, I am for the petitioner. On the last occasion, your lordships were pleased to
He is
call
not
for a
wanted in
status
connection with this case, my lord.
Petitioner is not wanted in the connection with this case. Accordingly, application for anticipatory bail is dismissed as not maintainable.
But report is kept with it.
Report is kept.
Great.
Next.
So, my lord, I appear for the petitioner, my lord. Lord, love affair, promise to marry. My lord, victim, is it about 35 years, my lord, married lady?
Married lady.
My lord, with 2 children, having 2 children.
We have considered the materials on record. Petitioner contends victim is a married lady and has falsely implicated him in the crime. Learned lawyer for the state opposes the prayer for bail. Learned lawyer for de facto complainant also opposes the prayer. We have considered the materials on record. Statement of it shows that petitioner and victim developed romantic relationship, romantic association and cohabited. She is a married lady. Whether cohabitation was out of developed an illicit relationship and whether the cohabitation was due to illicit relationship or on false promise of marriage as we assessed at the appropriate stage of the proceeding would serve custodial interrogation for purpose of investigation is not necessary.
One submission,
Grateful, my lord.
my lord, just one submission or instruction, and say the petitioner and the son of the petitioner is threatening the letter.
Each investigating officer wants it.
Grateful.
Don't petitioner shall not interact with the victim directly or through electronic means.
My lord.
My lord.
WhatsApp message, anything, please inform the police.
My lord.
Grateful.
You will have no contact with her.
Grateful.
ও যোগাযোগ করবে না আপনাকে।
Petition your lordship, my lord. There is a transit anticipatory bail prayer. It's a case of Haryana. It is an incident of 2023.
Status report has arrived. Your lordship, he was served with 41 in notice. He has not complied with total valuation of 8,16,000.
My lord,
Were
my name
collected from different accounts, and he was a kingpin. He was giving them 5% of the amount received. Charge sheet has been filed.
No, we are not going to. Do not press, otherwise we'll reject you.
No, I'm not present.
This sort of case, petitioner is at liberty. We have seen the report of Jhajar police station. Investigation is allegations involve. Report shows petitioner is involved in a criminal, is involved in a cyber crime, resulting in inducing
8,16,000 rupees.
Huh?
8,16,000.
Resulting in defraud of over 8 lakh rupees.
16,000.
Investigation is complete. In this backdrop, petitioner seeks leave to withdraw the application and apply before the jurisdictional court. With this, leave is granted. Application is dismissed as not.
Lordship, report be kept in the record.
Go and appear before regular court at bail. 5 minutes, sir. 5 minutes.
I'm for the petitioner.
Petitioner was assaulted by, the victim was assaulted by petitioner and some others. But postmortem report was not very specific about the nature of the death. So my lord directed me to obtain the further opinion of the doctor. It appears from the further opinion that it is homicidal. Death is homicidal due to assault.
Statements of petitioner contents that victim had died due to natural causes. He prayed for anticipatory bail. In light of the aforesaid submission, further opinion from PM doctor was called for. Report is placed on record. PM doctor opined death is due to intrathoracic and intra peritoneal hemorrhage, which is antemortem in nature and in all probability caused by physical assault. Full stop. Accordingly, physical assault, which accordingly the death is homicidal. Full stop. Statements of witnesses corroborate this opinion, and also petitioner and others had assaulted the victim. Hence, we are not inclined to grant anticipatory.
Grateful to you, Lordship.
Next.
I am for the petitioner. But allegation is section 363, 365, 34 of the Indian Penal Code, adding section 376. Well, the fact that my lord, there is a relationship between one Rajesh Dhabok and victim lady, that they fled away and subsequently they married with each other. But the petitioner allegation is that my lord, is the shelter both of them. That is the allegation.
Yes, he is
But
not the principal accused.
subsequently they got married.
Victim recovered.
She ran away, she
All
came
right,
back.
petitioner is not
submitted.
the principal accused. Victim had eloped with the principal accused, and it is contended they have married each other in view of the aforesaid development and the extent of complicity of the petitioner in the crime. We are inclined to grant answer.
Grateful.
Next.
Right, right.
My lord, I beg to appear for the petitioner. My lord, this is a very, my lord,
30, by 29, case and counter case.
My lord, here initially this petitioner,
Cheating.
no, my lord, not cheating. My lord, forgery, fraud, all these things are allegations are there. This complaint was lodged after 4 months. But this petitioner initially filed one complaint on which charge sheet has been submitted. My lord, this is the case diary which your lordship was pleased to call for. Well, in that, the allegation was under 498 and other sections. Well, the charge sheet has been submitted. Well, although no proof of marriage is there, but some photographs are there.
Let us see the 164 statement.
But no 161 statement. Only 161 statements are there. This is the case diary for this particular matter. In this case, the allegation is that she has been blackmailing him.
False allegation. Defective son's name is? Defective complainant son's name?
What gets it from Client
Petitioner contends she was married to one Akshay Shaha
husband
and had been subjected to torture over demand of dowry. She lodged criminal case being Malda PS case number 67624 dated 24/9/24. In retaliation, the present case has been lodged. She prays for Anticipatory, learned lawyer for the state produces both the case diaries. We have considered the materials on record. Petitioner had been driven out of the matrimonial home. She had lodged a criminal case alleging cruelty against the son of the de facto complainant on 24/9/2024. Subsequently, the present case has been instituted on the basis of an application under section 173 subsection 3 BNSS. In the said application, it is alleged petitioner's son had been induced by de facto complainant's son was induced by the petitioner to come to her residence and administered drugs and stupefying substance. Objectionable pictures were taken and through blackmail, large amount of money had been extorted out of him. Possibility of false implication due to prior criminal case cannot be ruled out. Under such circumstances, we are inclined to grant Anticipatory. Next.
Petitioner is the father-in-law. Hello, they are being punished. Father-in-law separately resides since 2021, 2024. My lord, this FIR. My lord, that is my lord.
allegation against him, he used to court hold of her when there is no one in the house.
22, this is the
We have considered the materials on record. Petitioner is the father-in-law of the victim lady. It's contended The de facto complainant wife is residing at her parental home
Since 2020.
since 2021. He prays for unsuitable and a lawyer for the state opposes the prayer. We have considered the materials on record. It is alleged in the FIR. It is alleged petitioner molested the victim wife. However, but petitioner contends she is residing at her parental home since 2001. Credibility of such allegation request to be assessed at appropriate stage of the proceeding. Investigation is complete. Accordingly, we are inclined to grant answer. Next.
Yes, sir.
But we are for the state.
But under section 126 to 172, 182 and 351(3) of the BNS Lordship. Lordship, thank you.
Injury report shows simple injury. And the aforesaid fact, we are inclined to grant answer. Next.
109 subsection 1 of the BNS. So that is 307 of the Indian Penal Code. But they had the petitioner along with one Narayan Dondapot went to the place where the victim was there, assaulted her with him with lathi.
We have considered the materials on record. Incident occurred in the course of a quarrel in a tea stall. De facto injury report does not disclose grievous injury. Under such circumstances, we are inclined to contact. Next.
From the house of the petitioner court.
Yes, we have considered the materials on record. It is alleged that petitioner was selling adulterated packaged drinking water. No forensic report showing that the seized water is unfit for human consumption
We have not received the report.
Is placed on record.
Yes.
A custodial interrogation for forensic custodial interrogation for progress of investigation is not necessary. Accordingly, we are trying to grant answer.
Grateful. Grateful.
Next.
দেখো 69 টা কত না 132 থেকেও তো 60 হচ্ছে প্রস্তুত ওখানে পুরো ডিটেইলস 30 করে পুরো ডিটেইলস লাগাইতে বলবো
It was Arjun Malat report of
But yesterday this matter was heard when your lordship was pleased, well, an argument was advanced from his side that it is not a cause of murder, well, he was drunk. So your lordship was pleased to.
He fell down, motorcycle.
No, my lord. Lordship, this is the first. My lord, the date of incident is of 3/11/2024. He succumbed on 9/11/2024. Lord, this is the first injury report. My lord, subsequently, from page 132 to page 137, there are details of all the hospitals he were taken from there. There are 5 hospitals where he were taken, shifted, and after all, he succumbed. My lord, all the details are there from page 132 to 137. And precisely on 134.
You're seeing physical.
Yes.
May I submit?
There are 2 164 statements. Yes.
He was taken, as per my instruction, he was taken someone, maybe his name is Nitai Pramanik. Can you see any statement of Nitai Pramanik under 161? He was in drunken condition, driving his motorcycle and pulled in a lamppost, subsequently sustained injury on his head. Can you see any injury in his body if I assault?
Nitai Pramanik, they picked up the patient from the road and carried him to the hospital.
Kindly see any 161 statement of Nitai Brahman?
What will he say? He'll just say that he was lying on the road with injury.
With drunken condition in motorbike. He pushed in a lamp post, sustained injury in his head.
Pramanik's statement is
My lord, it is page 26.
But he was also driving a motorcycle, right?
My lord, now your lordship will kindly seize the eyewitnesses 164. The eyewitnesses 164 is 173 and 174. Two eyewitnesses, Sujoy Bishwas, Shomit Pramanik.
They are the connected parties.
What is the explanation of the motorcycle? Where is the motorcycle?
Returning from the motorcycle.
My lord, he was riding the motorcycle, he was chased.
Where is it? That is what we
Lord, from the complaint, my lordship will find.
injury. PM.
My lord, PM 127.
There are only some bruises are there.
Yes, but my lord, the bruises and abrasions, but death was due to the effects of the injuries as noted above, antemortem and homicidal in nature.
Correct. There is only bruises and scalp hematoma. Only.
Now, my lord, lordship will kindly also consider page 148 to 165, the CK Birla medical reports, which shows there is an intracranial hemorrhage, multiple
Correct, that is
abrasions.
the scalp hematoma present
Yes,
on left
yes, yes,
temporal.
yes.
So that is because it may be hitting on the.
But my lord, the 164 statement of the eyewitnesses, it states something else.
Connected parties.
State everyone is assaulting.
Yes,
With so much of assault, only abrasions.
my lord, that is what I find. That is what.
We find also.
Yes, because I have the series.
People were assaulting.
My lord, one.
One.
No, no, no. 3-4 জন কে মারলো। না না মেরেছে একজনকে না 3-4 জন। মানে সুমন was assaulted by 8 to 10%.
8-10 জন।
হ্যাঁ 8-10 জন মানে 10 to 8 to 10 persons assaulted him.
সুমনকে বেধড়ক ইট আর লোহার রড দিয়ে মারধর করছে and only a few abrasions. Petitioner submits the victim had gone out on Kali Puja night for a drink. After consuming alcohol, he was driving home and hit a lamppost. As a result, he fell down and died. One Nimai Pramanik, a Toto driver, lifted him and took him to hospital. Subsequently, his family members implicated the petitioner, falsely implicated the petitioners or petitioner?
Petition.
Petitioner in the case, he prays for Anticipatory. Learned lawyer for the state subject. Petitioner was chased by the petitioners had chased the victim who was driving a motorcycle. They had physically assaulted him with bricks and iron rods. As a result, he suffered head injury and died. We have considered the materials on record. Admittedly, a victim had suffered head injury and died. PM report shows scalp hematoma, full stop. Apart from the hematoma, it notes some abrasions too. While petitioner's content, victim was driving in an inebriated condition and hit a lamppost, comma. Prosecution alleges he was physically assaulted by the petitioners. Prosecution relies on two purported eyewitnesses who claim they saw 8-10 persons, including the petitioner, assault the victim with rod and bricks. PM report, however, discloses mere abrasion apart from a scalp hematoma, which probably occurred due to a single hit. Multiple assaults by a group of 8 and 9 persons is not corroborated by the medical opinion. Full stop. On the other hand, possibility of few abrasions owing to a hit on the lamppost resulting in scalp hematoma is more probable. Be that as it may, the eyewitnesses are completely silent with regard to the motorcycle, which was noted at the spot by an independent witness, Nitai Pramanik, who took him, a tutor driver who took him to hospital. Note, in the FIR, the de facto complainant refers to the motorcycle, de facto complainant claims, de facto complainant mother, na?
Yes.
Mother of the victim claims she was informed by her son that he was driving a motorcycle when the petitioners chased and assaulted him. Medical papers placed before us show from the time of admission, the victim was unconscious and had not regained consciousness, which improbabilizes the so-called disclosure noted in the first information report. In this background, we are of the opinion the prosecution case suffers from various improbabilities and is riddled with contradictions. Defense version. On the other hand, circumstances emanating from materials collected during investigation probabilize the defense version of accidental injury. Hence, we are inclined to grant Anticipatory bail.
Deeply obliged. Deeply obliged.
Lordship, I'm for the petitioner, Lordship. Lordship, the petitioner is an employee of Kolkata Metro Rail Service, Lordship. In the year 2019, he, along with accused person number 1, took a personal loan of rupees 8 lakhs from the de facto complainant in 2 parts, 4 lakh each, Lordship. This petitioner took a loan amount of rupees 4 lakh from the de facto complainant and handed over 2 account pay checks, also amounting to rupees 4 lakhs. And 2 lakh rupees he has even repaid back, Lordship. Part payment completed, Lordship.
No, that
Civil
is
dispute,
not the
Lordship.
case. I would kindly see on the pretext of providing job in the railways, I would kindly see their entire modus operandi. False interview letters were given.
Petitioner submits that he had taken a loan from the de facto complainant and he has partly paid, returned and he has made part payment in
2 lakh.
regard to the loan. He prays for anticipatory bail and a lawyer for the state submit. Petitioner and others had hatched a conspiracy and induced the de facto complainant to pay money on the false promise of giving employment. Forged appointment letters were recovered.
And then fake training sessions in Howrah and railways.
Appointment letters and other documents were recovered in the course of investigation. We have considered the materials on record. Petitioner is a member of a gang which dishonestly induced the victim and others to part
Yes.
with money on the false promise of giving employment. They had prepared fake appointment letters and even arranged fake training sessions for the prospective appointees, keeping in mind the heinous conspiracy, the deep-rooted conspiracy, deep-rooted and ingenious conspiracy hatched by the petitioner and his associates to defraud unemployed youth of valuable money. We are not inclined to grant answer.
Great.
Next.
Case under section 318, 316, 351 and section 3 subsection 5 of BNS. My lord, in the year 2014, the de facto complainant, my lord, executed one power of attorney to the petitioner number 1. 2015, he sold the property to the petitioner number 2, her husband, and consideration money was paid in the name of
20 lakhs has already been paid. There was a part payment, 41 he complied. Everything is there.
We have considered the materials on record. Allegations involve non-payment of sale consideration, non-payment of part sale consideration to the de facto complainant. Nothing is placed on record to show petitioners had dishonest intention at the inception.
Moreover, 41 has already been.
Petitioners have cooperated with the investigation. Under such circumstances, we are inclined to grant.
Yes, deeply.
Next.
I'm grateful.
At 43, my lord, I beg to for the appellant. Lord, there is a delay of 90 days. I have
There
50,
is a 50. Can is filed 43.
43, my lord.
Can you have filed?
Yes, my lord. Can one.
Joydeep, appear. Copy of the application for coordination of delay is served upon Mr. Joydeep Roy, learned government advocate. Having considered amendments for coordination of delay, we condone the delay. Admitted, issue usual notices, call for records, delivered to pray for suspension upon notice to the suit. Next.
Deeply.
My lord, I am praying for leave to appear through online mode, my lord.
Yes.
My lord, in this instant case, your lordship, my lord, if your lordship kindly come to page 5 of the judgment, my lord. My lord.
Suspension of sentence upon notice. Next.
I'm deeply praying.
Next.
Okay.
48. Forty-eight.
48.
পেপার বুক হয়ে গেছে পিসিআর এসে গেছে পেপার বুকস be prepared within 6 weeks.
And inform her.
Oh, this one. Oh,
Well, yes, 304 charge, 302.
yes. Have you seen it?
Miss Sinha is there, yes. It's not, there's no alteration of charge done.
করে করলো
অনুসুয়াকে দেখবে অনুসুয়ার নম্বর আছে না
অন্য সময় ম্যাটার করতে আসছে আমি
ও।
টাইম নিচ্ছি
trial court records have been received.
Yes,
Mr. Ganguly, appearing for the appellant, takes a preliminary point. Preliminary point. He contends the appellants were convicted under section 302, 149, 149 too.
Yes.
302, 149 IPC. Although charge framed against them was under section 304,
143.
149 IPC. There was there was charge had not been amended and no opportunity to recall witnesses for cross-examination under section 216 CRPC had been granted, had been given to the appellant. This has amounted to a mistrial. As a result, his clients have been severely prejudiced, resulting in a mistrial. Full stop. On this score alone, he praised the judgment and order of conviction and sentence be set aside and matter be remanded.
Well, there is also a conviction charge was there under 326 and 307. I've been convicted of those also.
326, 307, that is also there, but we, since it's the principal charge, we are.
Yes, so that's, I just wanted to inform your lordship.
Learned additional public prosecutor contents. The appellants were named by the eyewitnesses named by the eyewitnesses and had participated in the assault. They have also been convicted under section 326
and 300 and 307.
and 307.
Well, he has convicted under section 326, 307, 302, 149. So it's not a conviction separate to that extent.
For the same assault.
Yes, no, there were, yes, same incident, different persons assaulted.
How many heads of charges were found?
326, 149.
এটাই তো আমাদের কাছে নেই।
Different assaults.
Different.
Different.
On different sets of persons.
চার্জটা তো নেই।
কালকে আমি দেখেছি
আরে ও তো
তিনটে head
আরে
page।
তাও তো
ওটা মার্ক করে রাখা ছিল।
Page
45,
35.
45.
Second file না, first file.
Page 35.
তিনটে হেডে।
3 heads.
That is the
26, 149.
149
107, 149.
ও সবেতেই
104,
140
149.
কিন্তু কনভিকশন দিয়েছে ওই সময় এক সময়
এখন 149 টা দেয়।
দিয়েছে
একটাতে দিয়েছে।
মানে
মানে
কমন করে দিয়েছে ব্র্যাকেট।
They had also been 304, 149, 307.
Well, may I take your lordship to the judgment? In a page 32.
Why should we go into the judgment when we have the head of charge here?
But when he convicted and he sentenced, he did not include 149 for.
It does not matter.
I understand.
When there's a charge under 149, 326 will be read as 326, 149. It hardly prejudices you. Just see car murder Mohammed Rafi. So for the murder of
Rafiqul Islam.
Rafiqul Islam, it is 304.
My lord.
She contends that the appellants were charged for causing assault on others under section, had been charged and convicted for causing assault on others under section 326, 149 and 307, 149 also. Prosecution case alleged against the appellants is as follows. On 22/5/2008, a tree had fallen down due to storm. The appellants and others removed the said tree. This ensued in a quarrel between the appellants and one Mosammed Tahomina Bibi, the de facto complainant. On the next day, that is 23/5/2008 at 10 a.m., the appellants and others started abusing Tahanoma and her family members. And when they raised objection, the appellants and other FIR named accused assaulted them with shabol, forsha, stick, and other weapons. As a result, Tahanoma's husband, Rahman,
Habibur Rahman.
Habibur Rahman, brother-in-law Abdul PW2, brother-in-law Abdullah PW,
Abdul Majid is PW7.
brother-in-law Abdullah
Abdul Majid.
Mojid PW7, Motibur Rahman
PW3.
PW3 and Rafiqul Islam deceased were injured. Rafiqul had been hit on the head with a forsha by
Abdul
Latif and Ataur.
Abdul Latif and Ataur
Rahman.
on the exhortations of Abdul Noor and
Obaidur Rahman.
Obaidul Rahman. Full stop. When the injured were taken to hospital, Rafiqul was declared dead and others were.
My lord, he expired. The incident took place on the 23rd, expired the next day on 20.
The injured were taken to hospital and Rafiqul expired on the next day. FIR came to be lodged by Mosammed Tahomina Bibi, PW1,
Yes,
resulting in registration of
Harish Chandrapur PS case number
85 of 2008.
Harish Chandrapur PS case number 85 2008 dated 23/5/2008 under section 143 25 26 506. Charge sheet was filed. In conclusion of investigation, charge sheet was filed under 143 23 323 324 325 326 304 506 against 14 accused, including the appellants. Appellants, along with 10 other accused, were put on trial on the following charge.
Two
were juvenile. So 2 and this 4 and
all right. Appellants and 12 others were tried.
No, my lord, appellant and 8 others.
8 others were.
So that makes it 12 plus 2 juvenile, 14.
Appellants and 8 others were tried in the course of the trial, whereas while two juvenile charge sheeted, while 2 juvenile accused were tried by the juvenile court, children court, full stop. Charges were framed under section 326/149 against the appellants for causing grievous hurt on Tahomina Bibi, Habibur Rahman, Abdul Rahman, Motipur Rahman, and Rafiqul Islam by means of sharp-cutting weapon, under section 307, 120, 179, 149 IPC for forming unlawful assembly and assaulting Tahamina Bibi, Habibur Rahman, Abdul Rahman, and Motibur Rahman with the intention to cause their death, and under section 304 149 IPC for causing death of Mohammad Rafiq alias Rafiqul Islam.
May I just come back in a minute?
It's up to you. What can we say? Trial in course of during trial, prosecution examined how many witnesses?
16.
16 witnesses and recorded 16 witnesses. In conclusion of trial, trial judge by impugned judgment and order inter alia convicted the appellants under section convicted the appellants under section
Well, it would be 32 in a page.
32.
Considering the evidence.
326, 307, 302, 149 IPC. Mr. Ganguly rightly assails the conviction under section 302, 149 IPC for the death of Sheikh Rafiq alias Rafiqul Islam. On this score,
What a judgment.
no charge under section 302, 149 IPC had been framed.
William Slaney
Had been framed and opportunity to cross-examine had been on the score that charge had not been amended, and the graver charge under section 302 149 IPC had been added, and opportunity of cross-examining the witnesses had not been given. Section 216
handbook name
CRPC inter alia provides
handbook
inter alia gives power to a court to add or alter any charge at any time before the judgment is pronounced. Subsection 3 Subsection 4 of the said section states, in the event such alteration in the opinion of the court would prejudice the accused or the prosecutor, the court is to adjourn, is to direct a new trial or adjourn the trial, and power to adjourn. The section 217 CRPC provides, if the charge is altered after commencement of trial, the prosecutor and the accused shall be allowed to recall witnesses and re-examine witnesses with reference to such alteration and or examine any new witness which is necessary and or examine any new witness unless the court for reasons recorded in writing recall and re-examine any witness recorded in writing that such examination is vexatious or would defeat the ends of justice. The parties, the prosecutor and accused shall also be allowed to call further witnesses if necessary. Would stop. Admittedly, the appellants have been convicted of a graver charge, namely murder, than the charges leveled against him, than charges framed against him. Stop. Conviction charges আচ্ছা তারপরে আরেকটা বলো সেকশন 464 CRPC provides admitted আচ্ছা কি বলবো admittedly the
জাজমেন্ট আনা উচিত ছিল তোদের উইলিয়ামস লেনি জাজমেন্ট তোদের না কোনো না ওই নেই
provides the we are conscious section 464 CRPC provides that no sentence or order of a competent court shall be deemed to be invalid on the ground that no charge is framed or on the ground of an error, omission or irregularity in the charge unless the same failures occasions failure of justice. Eita age diye tarpore bolo admittedly have been convicted. Conviction of an accused for a graver charge than what for a graver charge without reframing or altering the charge and giving an opportunity to him to recall the witnesses examined or examine further witnesses if necessary evidently prejudices his defense and occasions failure of justice. Such omission, in our estimation, cannot be glossed over by the saving clause under section 464 CRPC. The trial is certainly hit by the manner of the trial has certain the trial and the ensuing conviction certainly falls foul of the fair trial rights of the accused and amounts to a mistrial. Full stop. On this score alone, we are inclined to set aside the conviction and sentence, the judgment and conviction and sentence, and remand the matter for fresh consideration from fresh consideration by the and remand the matter for reframing the charge under section 149 IPC against the appellants 149 IPC against the appellants. After reframing the charge, the appellants would be entitled to recall witnesses for further examination under section 200 in terms of section 217 CRPC, and the trial shall be taken to its logical conclusion. We make it clear we have not expressed any opinion with regard to the validity of the convictions under the aforesaid charges and under the charges, validity of the convictions under the aforesaid charges, and the same shall be decided independently on the basis of evidence adduced, independently on the basis of evidence adduced, along with independently and on the basis of evidence adduced by the trial judge in accordance with law. Full stop. Appellants shall continue. We are informed appellants were on bail during the earlier trial. They shall continue. They shall continue on bail upon furnishing bond of so and so, bail bond of 10,000 rupees with 2 sureties of like amount to the satisfaction of the trial judge, and shall appear before the trial judge on every date of hearing and cooperate with the trial. The proceedings shall be, the trial judge shall conclude the proceedings and pronounce judgment as early as possible, preferably within 6 months from the date of communication of this judgment.
Deep
Full stop.
With regard to the acquitted 8,
We have not, they cannot be any acquittal.
your lordship has said judgment of conviction. Then
We have said conviction, we have said remand for the appellants.
oh, sorry. Deep.
Said remand for the appellants. There is no appeal against the state.
No, yes.
Acha. Needless to mention, the acquitted accused. We also note no appeal has been preferred against the acquittal of the other accused, and hence other accused. Full stop. We place on record that. That is why we have clarified.
Yes.
We have not expressed any opinion with the legality and validity of the conviction.
Indeed.
Only on this score it is remanded. Because since the gravest offense, there is a defect. What is the use?
I don't know how. Anyway, it has happened. It has happened.
Shouldn't have happened.
Alert?
Shouldn't have happened.
Shouldn't have happened.
Next.
Deep.
Code 64 will not take care. You are the prosecutor. You sleep. No way. No way.
Deep.
If you file an appeal, definite. You can even find an appeal after new evidence comes. Then we will examine that.
Yes.
Yeah, we'll call them finish.
Item number 51, my lord. I'm being led by Mr. Milord Mukherjee, my lord. I'm being led by Mr. Milord Mukherjee, item 51, my lord. I've been instructed to pray for an accommodation, my lord.
Out of list on the prayer of the appellant.
My lord,
Lord, I am happy for that.
55, appellant is directed to correct the paper book, adjourn 2 weeks.
May I be permitted to mention one thing, my lord? One order was passed by your lordship and thereby dismissed my application in single bench. Revisional application which was prepared for transfer of the case from one court to another. And on the dismissed on the ground that the vital document I could not show. But that was very much in my possession later on, my lord. But I have filed a petition, my lord, already a petition. At least to be mentioned. Oh, sorry. High level assistant, madam.
আপনি আছেন?
Madam, for the petitioner. My lord, petitioner herein is the aggrieved housewife, my lord. She got married to opposite party number 2 in the year 2017. Huge amount of dowry and other articles were given at that time. Thereafter, interim maintenance. Madam. Yes, my lord, but there are lapse of more than 3 years, my lord, in the. No, my lord, I have filed the affidavit of assessment level. Yes, my lord, on that date also.
But I am for the petitioners. Well, at 420, 406, the petitioners are the directors of a company which has not been made an accused. Without making the company an accused, these petitioners have been made vicariously liable. My lord, the company operates since 2005, and my lord, it caters to US nationals and in the, my lord, educational system. And my lord, lordship would, no. My lord, kindly sees, since 2005, this is 2024, 19 years without blemish, I am doing this. And my lord, kindly comes to the charge sheet. Apart from naming the petitioners as directors, nothing has been ascribed. My lord, not a single word. My lord, kindly comes one.
My lord, there are other grounds as well, my lord. There are other grounds. Yes. My lord would. But can I show your lordships the validity of my trade, my lord?
Running a call center under a ostensible business of trading retail and financial services and carrying on fishing business.
My lord,
No bona
my lord, it's with all legitimate permissions, my lord. And my lord, the
But for
FIR,
fishing,
it's not
for-
fishing, it's not fishing, my lord. My lord, what happens, my lord? These American universities, they seek admission of American students in their universities. Now, I am being appointed as an Indian agent. So what I do, my job is only lead generation. My lord, I call the students. If they are interested, I forward them to the university. If the student takes admission, I get a commission. This is my business since last 19 years. My lord, kindly sees the charge sheet. And who is the victim? My lord, there is no complaint by anybody that I have been defrauded by this company. That I have paid money, I have not given any placement. There is no such allegation. And my lord, there is no legal evidence because my employees, they were put under 41A notice and their statements were recorded under 161. They were the witnesses, my employees. And all have said that we are doing this business. And there is no monetary transaction. But my money comes from the American company. Once a student takes admission, look, there is absolutely no monetary transaction. Both my bank accounts have been freezed where money have come from abroad towards this, my commission.
petitioner, petitioner also submits that he was carrying on bona fide business of
Of lead generation.
of facilitating employment, facilitating admission of prospective Indian students to American
No, my lord, American students, not Indian students.
universities.
To American universities. My lord, what is happening? These American universities.
Facilitating admission of students in American universities.
Yes.
He has requisite licenses for carrying on the business. He prays for quashing of the proceeding. We have considered the materials on record. Impugned charge sheet, inter alia discloses, inter alia shows petitioner was carrying on business under the name and style of Anupam Technologies Private Limited. The business was the business activity of the petitioner involved as per charge sheet business under the business act as per charge sheet the petitioners were running an illegal call center and had cheated number of persons in the name of giving educational services, website development, medical services, gutter protection, etc.
But no indication who are the persons cheated.
The charge sheet also,
Sorry to interrupt, my lord.
The charge sheet also discloses money which was credited into various mule bank accounts of the company abroad. And the same was also routed into the in accounts maintained in Indian banks. Good stuff. But learned counsel strenuously argues that the business is a bona fide one, and no complaint was received that any individual had been cheated. Full stop. Uncontroverted allegations in the charge sheet prima facie disclose running of an illegal call center and cheating innocent individuals abroad on the under the guise of providing educational, medical, and other services. Full stop. It is in such view of in light of the aforesaid averments in the charge sheet, we are of the opinion institution of the proceeding cannot be said to be illegal, nor can the issuance of illegal. It is open to the petitioners to agitate his grievance at the appropriate stage of the proceeding in accordance with law, if so advised, at the appropriate stage of the proceeding, including the stage of consideration of charge in accordance with law, if so advised. Next.
My lord, I am for the petitioner. My lord, prayer of the petitioner to stay of warrant of arrest.
Why should warrant be stayed?
My lord, only one day he failed to appear. My lord,
Submits that he was unable to appear before the court, and due to circumstances beyond control, he prays for he prays for suspension of the warrant and issue suspension of the warrant and undertakes to appear before the court in accordance appear before the court and pray for regular bail. Copy of the application we served upon Miss Amita Gaur. Stop. Having considered the materials on record, in light of the aforesaid submission, we suspend the warrant of arrest issued against the petitioner for a period of 4 weeks, within which period petitioner shall appear before the jurisdictional court and pray for regular bail in accordance with law. In the event petitioner fails to do so, shall stand revived and be executed in accordance with law. Next.
My lord, I am for the petition in this matter.
Yes.
My lord, I have preferred an application for discharge. That application has been rejected against this order. My lord, I have preferred this application. My lord, in this case, my lord, the petitioner is a social worker. My lord, he raised objection against an illegal construction. My lord, and this is the reason, my lord, this FIR has been instituted against him. My lord, kindly consider page 37 P5, the order of this honorable court in read jurisdiction. My lord, against the illegal construction. My lord, I have preferred and read. My lord, this honorable court categorically stated this is illegal erection and demolition order is there. Thereafter, my lord, charge sheet has been submitted, and I, on the same date, I also prepared, my lord, another complaint, my lord, against the opposite party and his associates. They are the promoters, my lord, and in this case also charge sheet has been filed. My lord, see the discharge, the reaction order, my lord. Only allegation is that, my lord, that 10,000 rupees allegedly extorted from the opposite party by the petitioner, and that has been recovered from his money bag. And my lord, in the seizure list, I have annexed the entire 207 copy. In the seizure list, my lord, no note numbers, nothing is there. Only the money bag has been seized and 10,000 rupees.
Petitioner contents opposite party number 2 had undertaken illegal construction. He complained with regard in respect of the illegal construction. He had lodged complaint and instituted proceeding. In retaliation, the present case has been filed. Impugned criminal case was instituted. There are case counter cases.
Yes, my lord, case counter case, my lord. My lord, I initially lodged, my lord, the case. That is, my lord, page 25. My page 55, my lord, my case. FIR and the charge sheet has already been submitted in this case.
What is the case?
My lord, 20 under section, my lord, kindly see page. 55, my lord, my case. That is, my lord, under section 323, 341, 379, 506, 34. My lord, same date, my lord. Initially, I have brought this case. The associates of the opposite party came to my house.
You are Ramesh Jaswal?
Yes, my lord. I am Ramin Jaswal. My lord, the complaint page 55.
Where is his complaint?
My lord, this complaint, my lord, the associates are there, my lord. Their name,
Where is his complaint, which you wish to quash?
my lord, that is page 27. 27, the charge sheet, my lord, 27, the page 27, the charge sheet. And the FIR, my lord, page 16, 16. Page 16.
আচ্ছা কি বললাম জানো? He instituted a writ proceeding being WPA 11012 of 2022 in respect of the aforesaid writ with regard alleging illegal construction, and an honorable single judge directed his representation to be considered after in accordance with law. Thereafter, the de facto opposite party number 2 had physically assaulted him and snatched away money and gold ornaments. He lodged criminal case. In retaliation, impugned case has been lodged alleging he had demanded 3 lakhs. He had demanded 3 lakhs. He had demanded 3 lakhs. He had demanded 3 lakhs for failing which he would report the construction to the appropriate authorities and extorted 30,000 from the petitioner. Learned counsel submits that the allegations are patently absurd and clearly malafide, When did you make your representation with regard to illegal construction?
My lord, initially, my lord, in right to information, my lord, I have made an application. That is, my lord, on prior to the lodging of the FIR, my lord. Prior to lodging of
We have asked you when you have made your representation.
my lord, the date, my lord, I don't have the date. But don't have the date, my lord.
Fail to কি বললাম? Learned counsel contends learned magistrate failed to consider the absurdity of the allegations, failed to consider that the allegations are patently absurd and actuated with malice. Full stop. We have considered the materials on record. Petitioner had made representation alleging illegal construction. He had pursued the proceeding in WPA so and so, and a honorable single judge directed consideration of his representation. As a result, it is alleged he was physically assaulted by opposite party number 2. By opposite party number 2, demand of money from opposite party, demand of extorting money from opposite party. Admittedly, the material. What happened to the representation?
My lord, 1st April 2022, I have made the representation. There, 1st April 2022.
1st April 20.
Yes, my lord.
Right. Materials on record show that the representation for illegal construction precedes the date of demand of money, filling which the matter is alleged কি বললাম? Was on 1/4/2002, which precedes the date, the alleged date on which the extortion, on which the money is said to be extorted, failing which the matter is threatened to be reported to statutory authorities. This discloses the inherent absurdity. This discloses patent absurdity in the impugned allegations. Petitioner has made out an arguable case in a arguable case. There shall be stay of proceedings for 6 weeks. Copies.
Extremely lovely, my lord. Deeply lovely.
Please, your lordship. Now, this relates to a quashing of a proceeding under section 341, 323, 354, 509 and 114 of the Indian Penal Code.
Yes.
The petitioners and the opposite party, my lord, they are relatives, my lord, residing on the same floor of a house which is not yet divided, shared between the shareholders, my lord. And there, yes, my lord, I suffered injury. That is at page.
Suffered injury, they
Yes,
suffered injury.
my lord,
I'm not going to stay.
my lord, kindly seize my
Sir, if there is an injury, how can we stay it with a charge of 324?
323, my lord, so far as their
So
FIR
it
is.
should be, it's a triable issue.
But my-
Petitioner submits that they are owners of the property. There was a dispute. Petitioner also suffered injury. Case and counter case is registered. He prays for quashing of the proceeding. We have considered the materials on record, including the allegations in the first information report, where 71.
My lord, page 74, 75 is their FIR, impugned FIR.
Allegations in the first information report.
But only so far as 323, that appears to be there, my lord, but the other offenses, subject to my understanding, my lord, it is not made out.
Okay, but then that's a
Yes.
matter for charge.
I understand, my
But
lord.
we'll give you liberty to pray for discharge.
But
Yeah, আমার নোংরা
charge sheet has not yet been filed.
বাড়িতে আসি, তখন ঝামেলা করে আমার নর্মালি আমি খুব We have considered the materials on record. In the impugned first information report, it is alleged on the date of occurrence, that is 31/3/2024, a dispute cropped up between the petitioners and the opposite party number 2 over throwing garbage, and petitioners and petitioner and his son Shumon started assaulting opposite party number 2. The uncontroverted allegations prima facie disclose ingredients of the offense of assault. Learned counsel argues that the ingredients of other offenses are not disclosed. We are of the view this issue requires to be agitated at the stage of consideration of plea or charge. It's a 320.
My lord, charge sheet has not been filed.
We are of the view such issue may be agitated at the appropriate stage for consideration of charge/plea. In the event the police report is filed against the petitioners, with this observation, application is disposed of.
I am grateful.
Next.
My lord, I am appearing on behalf of the petitioner. Petitioner is the headmaster of a school. Allegation is on 29th of January 2024, when a boy of class 6, he was loitering outside of the school and he was not attending the school.
You slapped him.
My lord, he used a scale and gave on the leg, my lord. My lord, this is the allegation. CCTV footage was also seized.
So
Nothing is there, my lord.
That's right.
My lord,
Petitioner submits that
my lord, kindly appreciate 324, 341.
section
Cannot,
95 of the Indian Penal Code. All right, slight hard.
my lord, not hard at all. My,
You know what is section 95
my
of
lord,
Indian Penal? Mr. Jayant Chatterjee, please
my
read
lord,
section
section
95 of
90
Indian Penal Code.
My lord, my humble prayer is, I'm reading, my lord. Injury report is there. He said that only, my lord.
Mr. Chatterjee, we are not going to interfere
My
with,
lord,
a,
all right, my lord.
with a headmaster using corporeal force on a student. Simple. Right?
I understand, my
So
lord. I
if you
follow.
understand, then either withdraw or let us pass order.
My lord, then pass order, my lord.
Petitioner submits he is a headmaster and he is a headmaster of the school. He has been falsely implicated in the case. He had not exerted unreasonable force on the student and the ingredients of offense are not disclosed. Uncontroverted allegations in the first information report show petitioner had assaulted a student with fist and blows, full stop. As a result, the student had to be hospitalized, had to be treated in hospital, full stop. Mr. Chatterjee argues that the said the issue is a minor one and would be covered under the exceptions of the Indian Penal Code under section 95 would be covered under the exception of section 95 of the Indian Penal Code. We are of the considered view this defense requires to be thrashed out in the course of trial. However, when uncontroverted allegations disclose ingredients of the offense of physical uncontroverted allegations disclose ingredients of the offense of heart we due to physical assault, we are not inclined to quash the proceeding at this stage. It is open to the petitioner to agitate his defenses at the appropriate stage of the proceeding.
Grateful, my lord.
Next.
My lord, I am for the petitioner. My lord, I pray for my lord expeditious disposal of a maintenance case which is pending on 2018. I am the wife, my lord.
Why it is pending on 2018?
My lord, for evidence of the opposite party, my lord, it was pending, my lord. And my lord, you'll have to kindly see the date was fixed after lapse of 6 and 8 months later, my lord. Page 14, my lord, I am also one of the annex.
Yes. Why?
Page 14 also, my evidence of the opposite party. It is not in, my lord, they have been not deposed. And my lord, the matter is pending, my lord, since 2018.
Petitioner contends.
Next date was fixed on 24th of August 2025.
Maintenance proceeding is pending since 2018 due to non-appearance of opposite party. Full stop. We have, he prays for expeditious disposal of the proceeding. We have considered the materials on record. We have perused the order sheet. We note dates have been repeated, dates were fixed since 2023 for examination of the opposite party. However, the opposite party did not appear and the proceeding is hanging fire. It is right that maintenance proceedings require to be disposed of with utmost expedition. Courts ought not permit scheming litigants to misuse the process of law and dilate and delay such proceedings. Perusal of the order sheet would show repeated dates were fixed for examination of opposite party, but he avoided attending the court on one pretext or the other. Under such circumstances, we direct the learned trial magistrate to peremptorily fix the matter for examination of the opposite party, number one, and if opposite party number one does not appear, to close his evidence and dispose of the matter, preferably within 6 months from the next date fixed before.
The next date is 4th of August 2025.
All right.
My lord, after my lord 28th of December, my lord, the date was fixed on the 24th of. Kindly prepone the date, my lord.
We cannot. We are not the magistrate. We have no power to prepone dates. Dispose of the matter at an early date without granting unnecessary adjournment to either of the parties.
I deeply obliged.
Next.
My lord, 8 I am for the petition. My lord, in June 2006, the wife of the petitioner goes missing. My lord, 4 months thereafter, my lord, the FIR was registered by way of 156(3). My lord, thereafter, the reason for implication of the petitioner in the FIR appears to be that the son of the petitioner was forced to marry one person, namely Marufa Khatun, forcefully, and that the petitioner were accomplice there. Well, thereafter, first charge sheet was submitted. Nothing. Magistrate did not accepted the charge sheet for the investigation by directed. Well, when second charge sheet was submitted, the investigator came to finding that the victim is herself concealing herself in a different state at a parental house, and she has decided not to come to Calcutta and her residence. Well, thereafter, the petitioner preferred a writ petition, and this honorable court directed CID investigation.
Who are you? Complainant?
I am the petitioner accused person. My lord, we are facing the ordeal for more than 18 years. Neither we are facing trial, my lord. And my lord, this honorable court directed 6 months time frame to complete the investigation. That has also not reached any conclusion. This honorable court directed, my lord, that appears in 2023, my lord. And my lord, in second charge sheet, it is stated that the wife is concealing herself.
Where is he? Where is she?
My lord, that is as per the investigating officers.
She's concealing herself. That is for the investigating officer to.
It is investigating officers report.
Naturally, that is why the investigation is pending. What can be done?
Sections of kidnapping is not made out because it is she is at a parental house.
That would kindly see page 47, observation of IO in the second charge sheet.
In the victim, you can and end the case. Otherwise, we will not give our blessing to end.
My lord, I bow down before your lordship.
Bow down, we will dismiss the application.
The only thing, my lord, your lordship will monitor the investigation.
Whatever we have made ourselves clear, bring the victim or the IO has to be. Otherwise, we are not going to do this.
How can we find the victim?
You are not being vexed.
We call for IO repose.
wife of opposite party number 2 had gone missing on 17/6/2006. Acha, wait a minute. Elder son of opposite party number 2, Rajendra Prasad Kahar, was forcibly married to one Marufa Khatun, alias Dolly, on 8/6/2006. Full stop. 8/6/2006, at the behest of the petitioners. Stop. Thereafter, on 17/6/2006, wife of opposite party number 2's wife opposed the said forcible marriage. Petitioners, it is alleged petitioners nursed a grudge against her. On 17/6/2006, she went missing. As a result,
13th October.
Missing. On query, petitioner number 2 stated that the victim had been kidnapped by petitioners number 1 and 4 and one Uday Dasgupta and held in a secret location. A first information on the aforesaid allegations, a first information report was registered. Initially, the investigation resulted in filing of a final report.
No, my lord, charge sheet was submitted.
charge
But the magistrate did not accept it because
in filing of a charge sheet, as the victim had not been recovered, the jurisdictional magistrate did not accept the charge sheet and directed further investigation. Thereafter,
second charge.
In the meantime, opposite party number 2 also moved a writ petition seeking a writ of habeas corpus, being WP number 5589 of 2009. Well, this court directed the directed opposite party number 2 to file appropriate application before the jurisdictional magistrate. Pursuant thereto, opposite party number 2 filed an application before the jurisdictional magistrate for recovery of the victim girl. Finally, thereafter, in 2014, a charge sheet was filed wherein it was stated that the victim has intentionally secreted herself, wherein it was stated by the investigating officer that the victim is secreting herself and could not be traced.
At her parental home.
Secreting herself at her parental home. Full stop. However, no material in support of such allegation. However, no material in support of such statement was placed before the magistrate, and the magistrate directed further investigation in the matter.
No, my lord. Thereafter, the matter came up before this honorable court. In Sierra, there was a direction to transfer the investigation to CID. Well, that order at page 56 onwards, my lord.
Charge sheet is 2018.
Yes, my lord. Thereafter, my lord, for second charge sheet was submitted 2018. My lord, thereafter, this honorable court directed transfer of investigation to the CID and completing the investigation within 6 months. That order, your lordship will find at page 56 onwards. And the relevant portion of the order at page 89, where that was directed to be completed within 6 months and it was disposed of. But till today, there is no charge sheet.
তার আগে কি হ্যাঁ ওটা কেটে দাও আহ, ওটাও কেটে দাও বলো so first charge sheet was filed
Well, the first charge sheet was filed that your lordship 31 to 35.
in 2018, no?
No, that is 2010, my lord.
2010.
My lord, thereafter High Court's order, 4 years thereafter Nazi petition, thereafter the second charge sheet.
তার আগে no, no, that charge sheet was not accepted.
Both the charge sheet not accepted and the learned magistrate video order dated 14 3 2018 directed that you.
That's the second charge sheet. But
Like,
in 2010, charge sheet was accepted.
no, my lord. Thereafter again for the investigation.
2010
My lord.
charge sheet was perhaps accepted because they moved the writ petition.
Because in 14.6 लिखा है कि both the charge sheets have been sent
Because my
without
lord,
publication.
may I indicate, my lord, when the second charge sheet was submitted, both the charge sheets were returned.
Sir?
Both the charge sheets were returned.
Stating not
When the second charge sheet came into effect, both were returned.
Filed a charge sheet in 2010. তারপরে in the meantime directed.
Page 55. Page 55.
I have annexed that order.
They also filed a Narazi petition to the earlier charge sheet filed by the police. After conducting further investigation, police submitted a supplementary charge sheet in 2018. In the said charge sheet, it was observed that the petitioner is secreting himself. The victim is secreting herself at the parental home. Opposite party number 2 assailed the said these findings before this court in CRR 897 of 2019 and by order dated 27/2023, this court directed CID, Criminal Investigation Department, West Bengal, to conduct investigation and recover the victim lady. To conduct further investigation and recover the victim lady. Learned counsel submits the court had directed the investigation to be concluded in 6 months. Though more than 1.5 years have lapsed since then, investigation is not complete. They are facing the criminal proceeding for more than 2 decades. Accordingly, they pray for quashing of the proceedings. Stop. In light of the aforesaid submissions, we direct the matter to appear as contested application 4 weeks hence. Copy of the petition be served upon opposite party number 1 state through public prosecutor, 2 through registered speed post, file affidavit of service.
Much.
Next.
My lord, my application. My lord, these petitions are praying for quashing of a proceeding under section 3 IRAs of the Civil Code Civil Type Prevention of Atrocities.
Why?
My lord, because of the fact that my lord, because of the specific bar, my lord, if you lord can direct the learned trial court that on our surrender if our prayer for bail is considered, because admittedly there is a dispute from 2020.
All right, we say that consider that
Only
that if you appear,
because the public view is there now, quashing is not.
we have a petitioner prays for quashing of the quashing of impugned proceeding being so and so. We have examined the We have, he contends that there is prior enmity and case and count, and a series of number of cases are pending by and between the parties. The
My lord, page 12 of the charge sheet, after page 21, the charge sheet starts. The report says it has been established that there was a long pending dispute among the complainant and the accused person, specifically over the issue of drainage system. Page 12 of the charge sheet, inner page.
he also contends that the allegations of abusing opposite party number 2 by taking caste name is false and malafide. He prays for caution. We have examined the uncontroverted allegations in the first information report. It is alleged on 22nd January 2023 at 10:30, petitioners and others being variously armed had come to the residence of the opposite party number 2 and abused them, saying they are members of scheduled tribe and that they would be murdered. Good stuff. These aberments disclose offense under section 3(1)
My lord, RNS.
IRS of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. Accordingly, we are not inclined to quash the proceeding. Petitioner contends that they are ready and willing to appear before the trial court and pray for regular bail. We have they further submit the investigation is complete.
Incomplete.
If they submit investigation is complete, they submit that the investigation is complete and they have
My lord, they have attended the police station. They were served.
they cooperated with the investigation and charge sheet has been filed. In light of the aforesaid facts, we are of the opinion petitioners are at liberty. Under such circumstances, we direct the petitioners to appear before the jurisdictional special court within 2 weeks from here. And in the event the petitioners does so, the court shall consider the prayer for regular bail independently and in accordance with law, bearing in mind the fact that they cooperated with investigation and were not arrested during investigation.
Grateful.
And as they had cooperated and had not been arrested during investigation, and shall consider the prayer for regular bail in view of the directions given in Satyendra Kumar Artil, bearing in mind the fact that they had cooperated with investigation and had not been arrested therein.
I'm grateful.
So you are entitled to a notice summons. Warrant was issued.
No warrant.
So you
Entitled
as
to
you
it.
appear, you will be given summons.
I'm
You
grateful.
will be released on your bond. 88.
88.
Next. Then not today. 11.
My lord, I'm praying for not today, my lord. I am not having all the annexes with me, my lord.
Not today.
Gratefully, your lordship.
12.
My Lord, 12, I'm for the petitioner. My Lord, on 21st of November 2022, the petitioner number 1 gets married to the opposite party. My Lord, in July 2024, she files a 498A FIR, my Lord. The FIR, your Lordship would find on page 39. My Lord, in that FIR, she has stated that since 29th of February 2023, she stopped living with the husband. That is the petitioner number 1. My Lord, the 498A proceeding has been stayed by a coordinate bench of this honorable court. That order your Lordship would find on page 37. My Lord, subsequent to that, my Lord, in 2024, in February, she files a DV proceeding against the petitioner and his family, petitioner number 1 and his family members, my Lord. I'm praying for quashing of that DV application. My Lord, in the
No question of DV. Monetary relief she is entitled to pursue. Economic abuse.
my Lord, but this is on the self same. My Lord, the allegations that have been leveled in the 498A case, it's similar allegations in the DV proceedings.
What
my Lord.
about 498A case does not take care of monetary relief? Show us that you are paying 20,000 rupees per month to the wife and the child will state. Petitioner submits the opposite party number 2 had withdrawn from the matrimonial home on
My Lord, 27th of February 2023, which your Lordship would find on page 40.
27th February 2023. Thereafter, she lodged lodged a criminal case alleging cruelty, being English Bazar PS Women PS case number 141 of 2023, which has been stayed by this court in CRR 824 of 2024. Subsequent thereto, impugn proceeding under section 12 of the Domestic Violence Protection of Women from Domestic Violence DV Act has been instituted on similar allegations. Accordingly, Learned Counsel pleads for quashing of the said proceeding. We have considered the materials on record. Allegation proceeding criminal prosecution under section 498A 34 of Indian Penal Code is different from a proceeding under section 12 of the Domestic Violence Act. While the former is a prosecution for commission of a crime, prosecution for committing cruelty, mental and physical cruelty on a housewife for demand of dowry or of such nature which is likely to drive her to commit suicide or cause grave injury to her health, body or mind, the latter proceeding has a much wider ambit, including economic abuse, that is non-payment of monetary non-payment of monetary relief to the aggrieved wife. The scope and ambit of the proceeding under section 12 of the Protection of Women for Domestic Violence Act is much wider. Much wider. It is argued that the allegations in the criminal proceeding, allegations of cruelty in the criminal proceeding is much wider, and a stay in the criminal proceedings and a stay of the criminal prosecution would not justify stultifying proceedings under the Domestic Violence Act, which inter alia provide for monetary relief, which inter alia provide for residence order, custody, monetary relief, and compensation. In such view of the matter, we do not find any reason to interfere with the impugned proceeding. It is open to the petitioner to canvass their grievances before their defenses before the learned magistrate in accordance with law, if so advised.
Grateful, my lord.
Next.
Yes, my lord, I am for the petition. My lord, it is a case, my lord. Praying for the
125 praying.
Impossible. It is very much. It is impossible.
Impossible.
Impossible. It is true, my lord.
How it will be?
No, I am saying, my lord, 125 passing, my lord, it is very not possible. My lord, kindly consider, kindly say, my lord, kindly see the page, my lord. 47, my lord.
47.
Nullity. Petitioner, that is wife, herself filed an application for the nullity of the marriage. Now, it is true, my lord, he is entitled, though she is entitled. After divorce, he is entitled. It is true. Well, ongoing, my lord, most probably she decided to further marry or anything else, my lord. Now, my lord, this aspect, my lord, when she herself filed an application for nullity, then she is not willing to
On what ground nullity?
non-consummation.
Huh?
Not consummated.
Non-consummation.
Yes.
Petitioner
Post ongoing PhD.
assails proceeding under 125 CRPC on the ground that the opposite party wife has prayed for a decree of nullity on the ground of non-consummation of marriage. We have considered the averments in the matrimonial suit filed by the opposite party number 2 wife vis-a-vis.
And husband also filed, my lord.
Allow করেছে।
Yes, my lord. Both side filed. Not consummated, they are saying, my lord.
First pay, you are 8 lakh, you are earning 8 lakh per month.
No, my lord.
Yes, yes.
Yes, he is saying, my lord. My lord, he is also ongoing PhD, my lord. Husband, wife also, my lord.
We say 8 lakhs, pay 1 lakh per month, we will stay proceedings. 1 lakh to wife per month, we will stay the proceedings.
And most probably wife was also, my lord,
We
PhD
are
course
not
completed the PhD, my lord.
pay 1 lakh, we will stay the proceedings.
I have to get instruction, otherwise, my lord, the
Why waste your time, our time?
Yes,
Let it go to magistrate, then again he will come.
otherwise, my lord, client will say without consent, my lord.
First time, American client, one application done. Second time, again, you will come. Don't worry.
My lord, if interrupt, my lord, only humble submission, my lord. In the meantime, my lord, to serve the copy at least, my lord. To only serve the copy.
Anything upon deposit of 1 lakh.
No, to only to serve the copy.
Yes, only to serve 1 lakh.
Only serve.
Yes.
Not interim, my lord. To serve the copy.
Nothing. Admission 1 lakh. Wife has to contest against you.
Let her come, whether she will
No,
continue or not. Willingness, her willingness, my lord.
My government will be burdened by another high court legal aid lawyer. So you pay 1 lakh, wife will get 1 lakh, contest the application. Otherwise, go to trial. Magistrate. Go to magistrate. Matrimonial suit. In the application, in the impugned application seeking maintenance, opposite party number 2 wife unequivocally stated that the marriage has been solemnized on 30/10/2022 according to Special Marriage Act to 1954. In the whereas marriage petitioner also admits the marriage in such in this but opposite party number wife has prayed for nullity of marriage on the ground of non-consummation. This prayer by no stretch of imagination disputes the existence of a marital tie between the parties and her claim to maintenance. Accordingly, we are of the opinion there was no jurisdictional error on the part of the magistrate to entertain the prayer for maintenance. According, hence, application is dismissed.
Yes.
Chalo. Other matters tomorrow? We sit early. Not from 3. Try to sit before that.
Tomorrow I have some personal difficulty. Item number 30.
Whatever is there, you are not there, we get. Acha. Whatever you are not there, we will accept.